Welcome back to our YouTube channel. Today we're going to talk about patents and why they're essential to your business. So patents are extremely valuable because they can help you stay competitive in the marketplace and help you stop your competitors from stealing your intellectual property, your ideas, and using your innovations without your authorization. So simply put, a patent is a legal instrument that in certain situations entitles you to damages against infringers. So what does that mean? Well, essentially it allows you to stop other people from making, using, importing, and selling your invention. So it's really important for business because when you're in the marketplace, you might have some competitors. And so patents, if used and filed for correctly, can help you eliminate those competitors from competing directly against you using your same inventions. So now that I've given you the fundamental basics of what a patent is, I'm going to outline some key points about patents and some details that you really need to know and that can help you tremendously in your business. So most products that you buy and that you're familiar with, like phones, glasses, all these various items that you come in contact with every single day have patents, utility and design patents behind them fundamentally that protect those products. So now it's important to remember patents are different from copyrights and trademarks. All right? So copyrights protect original works that are reduced to a tangible medium, and trademarks protect source identifiers such as logos and brand names for goods. Now, patents are different. Patents should not be confused with copyrights and trademarks. So you might be asking yourself, why do I need a patent, and do I need a patent to start my business? Now, in a lot of situations, the answer is that a patent can be extremely valuable and extremely helpful in developing your business and strengthening your market share. Now, depending on what your funding is and what your idea is, it may be more appropriate to pursue a trademark or a copyright. Now I'm going to answer some really common questions that people have about patents. What can be patented? Well, one rule of thumb is anything under the sun. So anything that's new and useful, and new is important. In other words, it couldn't have been done before. So it has to be new and non-obvious, and it has to have utility. So it has to solve some problem. And if it can, then it's more than likely patentable. So what is the purpose of a patent? Well, the purpose of a patent is, as I said before, it's an intangible right that affords you the opportunity to exclude others from making and using your invention. So if a competitor, for example, rips off your invention, and makes and use your patented, say, device or, say, novel method without your authorization, in other words, without paying you royalty fees, for example, then you could possibly prevent them. So you can enjoin them from continuing that activity, or you can force them to have to pay you royalties for doing so. So there's generally three types of patents. So what are the three types of patents? Well, there are utility patents, there's design patents, and there's plant patents. Utility patents protect the structure and function of things, of items. Design patents protect ornamental features of an object, and plant patents protect plants in some special situations. Now, how long does it take to get a patent once after you've filed it? Well, this actually varies tremendously, but anywhere between 2 to 5 years, it is possible to get a patent issued more quickly if you file what's called a Track 1 request. Now, that significantly increases the filing fees, but the Patent Office guarantees that you'll have a final disposition, in other words, an allowance or a final rejection within 12 months. But again, it's a little more expensive. But if you go the conventional route, you're looking at anywhere from 2 to 5 years. Now, after it issues, well, then you have to ask yourself, well, how long is a patent valid? Well, patents are going to be valid for 20 years from the earliest filing date. So what does that mean? Well, that means that if you file, and sometimes there's some delays that are due to the Patent Office, and those can be used in adjusting the length of the patent. But for the most part, a good safe estimate is that day that you file your patent. Now, the big gotcha, remember that if you file a provisional patent application, that time can be started back from when you filed your provisional. Now, how much is a patent? Well, for a small entity right now, a patent is $830 in terms of filing fees. You're looking at three basic fees. There's a basic filing fee, the examination fee, and the search fee. So unfortunately, the Patent Office doesn't make it very easy to navigate the schedule of fees, but again, $830. If you're a micro entity, the filing fee is $455, and if you're an undiscounted entity, it's $1,720, so $1,720. Now, that does not obviously include legal fees. For example, if you hire a licensed professional, such as a patent agent or a patent attorney, and I'll get into what a patent attorney and a patent agent is later in this video. Again, some people will try to see if they can get patents for free or for cheap, but remember, these documents are legal instruments, and so a lot of energy goes into actually crafting these documents. And so for the most part, it's highly recommended that you seek professional advice when you're preparing a patent application. And often it's more than worth it to hire a professional and pay their fees in order to get a very quality work product. So as I mentioned before, you can hire a patent attorney or you can hire a patent agent. So what's the difference? Well, a patent agent isn't a licensed attorney. However, they've passed the patent bar examination. And what that means? Well, that means that they have a technical background. So for example, a BS in science, or they've passed the engineering fundamentals exam, or they've taken sufficient coursework to sit for the patent bar exam. So again, patent agents have passed the patent bar but aren't licensed attorneys. Patent attorneys, on the other hand, are licensed attorneys in at least one jurisdiction. For example, I'm licensed as a California attorney, but I've also taken the patent bar. Now, a lot of you in your business experience may have heard of patent trolls, also referred to as non-practicing entities. So what's a patent troll? Well, a patent troll is an entity that doesn't actually make a good or service, but instead collects purchases, for example, or somehow obtains the rights to sue other infringers. And so even though they don't make a good or offer a service, what they do is they collect patents and then assert them against entities and collect damages and licensing revenue. That's generally what a patent troll is considered to be. So the Patent Office is the government agency that actually examines and reviews patent applications and decides whether or not they're actually new and novel and merit an issued patent. So the Patent Office has many patent examiners. Your patent application after you file will be assigned to an examiner, and the examiner will actually issue office actions and cite prior art, but ultimately you have to go through the US Patent Office in order to get a US patent. So what are some reasons why you may not want a patent? Well, the big reason is if it costs, right? Because it can be quite expensive to get a patent, and so if it's very costly and you're just starting out your business, then cost might be a serious consideration. But let me give you some pro tips as to some really thoughtful reasons as to why you may not want to patent something. Now, the first thing to remember is that a patent is only worth as much as you're willing to invest to protect your patent. In other words, asserting your patent against an infringer is very costly. So if in your horizon you have no intent to ever actually assert your patent, then that may be a reason as to why you may not want to divert resources into protecting your invention. A second common reason as to why you may not want to patent something is if it's very difficult to detect infringement. In other words, if it's really difficult to figure out if your competitors are in fact infringing on your patent. So for example, if you have a special method, but it's only done internally and the outside customer never sees how you actually make the product, patenting that internal method may make no sense. Unless, of course, it's really easy to detect from the finished product whether or not that method was used. And so in those cases, we often recommend that people get trade secrets instead of patents. Thanks so much for watching this video. We really hope that this content helps you in your business and helps you navigate the patent world. And hopefully you'll find some of this useful when you're going out and deciding whether or not you might want to pursue patent protection for your innovations. Thanks for watching.